I am an attorney. I worked for 10 years doing business litigation, representing some cases that involved architecture, construction, and interior design. I also teach 2 courses at UCLA Extension's interior design program now about interior design law. And I'll be talking a little bit about some legal topics that are called for my courses. If you are interested, the courses they're being offered again in the fall, and they are also being offered online. Come talk to me afterwards if you'd like some more information about the courses, or take one of the cards that I've left here on the table. I'm also going to be talking in the capacity of a fine art dealer. I also am an art dealer. I have a gallery in Santa Monica called the Glass Garage Gallery at the Bergamot Station Art Center. So I'll be talking a little bit about ways that designers and fine art dealers can collaborate to solve problems that might seem difficult at the outset. So who here has ever been involved in a legal dispute? You don't have to say if you won or lost or how many years you served. Not that many people. I'm surprised. Okay. Well, I have a lot of empathy for designers, because I mean, essentially, you probably went into this because you're a right-brain person. You're an artist. You're creative. You wanted to create spaces that spoke to people's aesthetics. But you're tasked with a whole lot more than that, and I really feel for you. You're tasked with being with being an entrepreneur, with developing a business, with dealing with engineering issues, dealing with client psychology, sometimes dealing between the spouses, so you feel like a marriage counselor. And on top of that, you're asked to deal with legal issues all the time, and people wing it because you can't turn to an attorney every time you have a question, or you think you can't. And there are some easy things that you can learn that can help you. They're very basic information. This is not meant to be legal advice. If you really have a legal issue, really talk to an attorney. It's worth the $300. So think of this as not law school. This is like first aid or CPR, but some basic concepts that you should be aware of to develop some street smarts about. Okay, there are 5 of them. 5 little-known legal nuggets that could seriously kick or save your butt. Nugget number 1, vague terms in contracts with clients. Does everybody here actually get a written agreement with their client when you work with them? Is anybody not who's going to admit that? No, every single one is so good about contracts. I'm so glad to hear that, and I'm really kind of skeptical. But when you do get a contract, there are some things that you're probably downloading forms from ASID or AIA, and those are very good forms. But the important thing is to understand the forms need to be specialized and particularized for the client. And there are a lot of invisible things that you might not see. And one of the big things is ambiguity in the terms of the contracts. Oh, I forgot something. This is based on California law because my courses are taught through UCLA, so I'm teaching California law, but the concepts are general and applicable in a lot of states. If you have a specific issue, you'd want to talk to somebody who's familiar with the law of the state that you're in, but these are general concepts that do apply broadly. So, vague terms. Many legal disputes arise because the designer and the client did not have the same understanding about what the contract meant because the term was left vague and undefined. Often the term is one that is used by non-designers but has a different meaning when used in the interior design industry. So let me give you an example. There is a company that does architectural metal work called Murray Iron Works in West Hollywood on Melrose Avenue. They are a well-regarded company. They've done metal work for over 1,100 five-star hotels. One of their big projects right here in town is the Grand Staircase at the Bellagio. They had a client come in. The client was represented by a designer, but the client came in on his own with his wife. And they wanted some work done. They wanted work done in a French neoclassical style on railings and staircases. And they came in and they saw Murray Ironworks working on this chandelier, gold leafing this chandelier. And they asked, well, what do you do with all the flakes that fall on the ground? Do you recycle them? And Murray Ironworks said, no, we don't recycle them because they have no inherent value. That's imitation gold leaf. And the client said, well, imitation, that doesn't sound great. I'd like to have real gold leaf on my project. And Murray Ironworks said, we don't do real gold leaf. We don't even have anybody that can do it. So that's the end of the discussions in the showroom. They proceed forward, and Murray Ironworks gives a bid on this project. And it's a big project. The project was for two pairs of large doors with ironwork and railings on balconies and staircases, and then one large staircase. All of it to be covered in gold leaf. The project was bidded out at $193,000 in 2001, which is approximately $263,000 adjusted for inflation. So it was a big job. And here's what the description in the contract with the client said. The iron was to be finished with exterior grade, hand-painted premium scratch and mar resistant finish with rust inhibiting primer and seal coat, including dark gold leaf details. You see where this is going. So the client pays for less than half of the job, and the job is completed, and the designer for the client, who was not that involved, I guess, comes in and says, "It looks fabulous. We are so thrilled. It's gorgeous. It's beautiful. We're so happy." But then later on in the cleanup process, the client found a box, and the box was of the gold leaf finish, and it said that it was imitation gold leaf. And the client was furious. The client said, "This is not what I paid for. I said I wanted real gold leaf." And Murray Ironworks said, "Well, we told you we don't do it. We couldn't have done it. We don't have anybody that knows how to do it. And plus, it's unreasonable to think that with that much ironwork that we could use real gold leaf. I mean, don't you know economics? I mean, this is a big job, but to have that many pounds and pounds of gold, you would never have gotten it for less than $200,000. And the client said, "No, I told you to bid it out properly. I specifically brought it up for that reason. Why do you think I brought it up?" So it's he said, back and forth, back and forth. And the court ultimately agreed with the client, with the designer. It's a happy story. The court ultimately agreed with the designer and said that it wasn't the conversations. It wasn't the conversations about who said what, because this description is right down the middle. It says gold leaf. It doesn't say imitation gold leaf. It doesn't say real gold leaf. It's right down the middle, ambiguous. So if you're stepping in as neither a designer or this particular client, you're going to throw your hands up and say, "I don't know how to decide." So the way that the court decided was they looked at the economics of it, and they looked at the cost of it, and they realized that no reasonable person could have expected that they would get this amount of, the raw metal for this price. And there was some testimony from expert witnesses in the form of interior designers about what would be reasonable to understand from this contract, and that was determinative. So it is a happy ending for the designer, and the designer got paid, but the designer paid for a lot of attorney's fees and had a lot of headache and stress in the process, and all of this could have been eliminated with the addition of one word: imitation. So that's easy for us to see now. It's not so easy to see at the outset, but you have to step back a little bit and have a lot of conversations with your clients at the outset. When you talk about a project, the more conversations you have, the more you'll understand what assumptions you're making, where the holes are in your understanding between the terms that you use in the industry and the terms that your client uses as a layperson. So that's nugget number one. Number two, non-disclosure agreements for prospective clients. Does everybody know what a non-disclosure or an NDA is? Okay. For those of you who don't know, it is not a contract to hire somebody, but it's an agreement that whatever we discuss here in the context of deciding whether you want to hire me or not, you're not going to use it outside of this context. So the dynamics at the beginning of the relationship with a prospective client are thus. You want to impress the prospective clients by sharing your creative ideas and demonstrating, as Aaron Danzig was saying, how unique your vision is and how unique your aesthetic implementation is going to be. It's hard to convince a client to do that showing them nothing. You are working in a visual industry. They're expecting a visual product. So if you have some very unusual idea, you want to share that with them because you want to get the job. On the other hand, the client wants to see it too. The client wants to see the creative ideas, but the client's not going to want to sign a long contract before they even decide to hire you. They're just shopping around right now. So those are the dynamics why you can't just say, "Here, sign this," and kathunk, and have a big contract. And the middle ground solution can be a non-disclosure agreement. They can be very short. They can be one page. The client's not obligated to hire you. You make that very clear. This is just saying whatever we discuss here, whatever I disclose here, whether it's told orally or it's presented in a visual format, you're not going to use them without paying me for it because you got this idea through me. And you might get some resistance from clients even with that modest proposal. But one thing that you can say, and that has often worked, is you kick it to your insurance company and you say, look, I have professional liability insurance. My insurer says I've got to get this to cover myself. It's their policy. Now, you can only say that if that's actually the case, but you can often write to your insurance broker and say, look, I would like to get a statement from the insurance company urging me to do this. And then you're covered because then you are representing that this is the preferred practice and policy of your insurance broker and insurance company. Okay, let's look at some examples of this. This is a sad story. You won't like this story. We're going to call this the Italian-themed hotel in Las Vegas. It's a hotel in Vegas. No, we don't need to mention its name because there was some bad behavior. All right, this hotel. This hotel hired a designer in Los Angeles. The designer in Los Angeles went to a showroom in Los Angeles and found 10 of these sconces and bought 10 of these sconces. Loved them, and the Italian-themed hotel was this LA designer's client, and was preparing to do a massive remodel of its hotel and other properties that it owns. So the hotel tells the LA designer to contact whoever created this beautiful sconce, and the LA designer finds out that it's a designer in San Francisco, whose name I'm not going to mention, and says, give us a bid. We have this big project. We need 11,000 of these sconces. And the designer's excited about this, obviously. He had never mass-produced these before. But it was tricky because the originals are very high quality, and they could not charge that price for this volume. It would have been cost prohibitive. They knew that from the outset, that they would be priced out if they priced it just multiplying what they normally sold it for by 11,363. So the San Francisco designer that came up with this original design went to a lot of effort and found a company in China, you see where this is going, called Diamond Life Lighting Manufacturing. I can name them, and had them give the designer a bid for how much it would cost to do this mass project, and they were able to meet the San Francisco designer's quality standards and also come in at a great price. So the San Francisco designer comes in with this whole package saying, I'm ready, I've got my operations ready to go, here's the setup, you're going to love the product, I have confidence in these people, when can I start? And San Francisco designer never hears back from the Italian-themed hotel, and he finally calls up and he finds out, well, no, we gave the job to somebody else. And the San Francisco designer says, okay, thank you for the opportunity, can I know who you chose? And no response. Months later, the San Francisco designer gets a call from a colleague, another designer, saying, congratulations, I'm here at the Italian-themed hotel, and your sconces look incredible in the hotel. And San Francisco designer flies down, gets a room at the Italian-themed hotel, and sees what's been done. And they are almost exact copies. The only difference is that there aren't 11,363 of them. There are over 13,000 of them now. So the San Francisco designer sues everybody. Sues the LA designer, sues the Italian-themed hotel. And the San Francisco designer's attorney is probably beating him up at this point because he did not copyright this. But then again, he couldn't have copyrighted it because copyrights are for works of art, not for functional items generally, as a general rule. He could have gotten a design patent for it, but that's a very long and expensive process. He didn't do any of that. So the attorney's running around and saying, okay, what can we claim? Well, we can claim that there was an implied contract because you didn't get anything signed. You didn't get an NDA or anything like that, right? And the designer says, no, I didn't. I just went in there and my actions created a contract, and their actions accepting this information, that created a contract. They weren't going to use this without cutting me in. And it turns out, I'm sorry, I forgot one part. It turns out that, in fact, what happened was that the LA designer contacted Diamond Life Manufacturing directly and set this all up, cutting out the San Francisco designer. So, and so the court looked at this, and the court was sympathetic to the San Francisco designer, but the problem was that there was no action on the part of the hotel saying that we won't use this idea, we won't use this design without cutting you in. Number one, the San Francisco designer didn't have any intellectual property rights registered for this. Number two, the San Francisco designer had already sold these in showrooms, so anybody could have bought one and copied them. And in fact, I almost said the name of the hotel. The Italian-themed hotel bought 10 of these. They didn't have to get this bid. They could have just taken those 10 that they bought and set it up themselves, found a manufacturer themselves. And then the San Francisco designer says, well, I found Diamond Life Manufacturing for you. That's, I mean, yeah, that resonates in fairness, but you don't own Diamond Life Manufacturing. You don't own that information. The court also pointed out that these sconces were, they had been placed in a couple of very high-profile properties. They had been profiled in magazines. The designer had promoted them by doing interviews in magazines about them. So they were already out there. The idea, the design, the visual was out there, and the San Francisco designer lost the case. So if the San Francisco designer had had that one-page NDA, this would be a very different story.